Buenas tardes. La Academia Madritense del Notariado se honra en recibir para la conferencia inaugural de este nuevo curso al profesor Murray. Es para nosotros un alto honor y creo no equivocarme que es la primera vez que tenemos en esta casa a un conferenciante norteamericano. El curso que se inaugura está dedicado a la memoria de un queridísimo compañero, Antonio Ipiens Llorca, recientemente fallecido después de una vida centenaria dedicada en todo momento al servicio a los demás. Perteneció al cuerpo de notarios, fue letrado de la Dirección General de los Registros en un momento que podríamos calificar como su época dorada. Todos añoramos, los que ya llevamos tantos años en el notariado, más de los que quisiéramos, porque nos quedan menos. Todos recordamos su labor en los tribunales de oposiciones, aquellas resoluciones de la Dirección General que marcaron efectivamente una época y que constituyen en todo momento un ejemplo para todos nosotros. Están con nosotros el director general de los registros y el notariado, nuestro querido Pedro Garrido, viene en representación de la ministra de Justicia, que se ha excusado por obligaciones propias de su cargo, pero que hubiera deseado estar aquí con nosotros y compartir este momento inaugural. Y sin más preámbulo, cedo la palabra al secretario de la Academia Madritense del Notariado, que va a realizar la presentación de nuestro conferenciante. También está con nosotros, querido Jens Bormann, presidente del Notariado alemán, y que ha tenido la amabilidad de desplazarse hasta Madrid para precisamente asistir a esta conferencia. Y como decía, sin más preámbulo, tiene la palabra José Aristónico García Sánchez.
Hola, buenas tardes. Antes de la presentación del conferenciante de hoy, quería indicaros que ya está editado el tomo 59 de los anales de esta academia correspondiente al curso pasado y que la próxima semana se distribuirá. Ya sabéis que es costumbre que en la presentación del siguiente curso aparezca ya el tomo anterior a efectos de que no se desactualicen las conferencias. También hay que decir que el calendario de este curso está ya cerrado también, que será dedicado a 2 leyes, exclusivamente a temas muy importantes y muy específicos del notario. La legislación sobre las personas con capacidad limitada y la ley de crédito inmobiliario, y todas las demás conferencias se destinarán a la informática, a la electrónica, en concreto también a la digitalización de sociedades. Hoy, como ha dicho el decano, dictará la conferencia inaugural de este curso el eximio profesor Peter Murray. Consistirá, como también ha dicho, en un juiciamiento desde la perspectiva anglosajona, más concretamente estadounidense, del sistema de justicia preventiva continental europeo, cuyo eje es el notario, analizando su papel en las transacciones de bienes raíces y el derecho societario. El profesor Murray ha estudiado durante más de 3 años en la propia Alemania el derecho alemán y muy especialmente las instituciones en que se asienta el sistema de justicia preventiva en este país, muy similar al nuestro, singularmente la naturaleza y funciones de los notarios alemanes. Y formulará una comparación argumentada de este sistema con el de las instituciones legales que hacen de los ponentes. Y para no cansar a la audiencia, no me extenderé en enumerar los méritos, las virtudes y los honores del conferenciante, que son extraordinarios. Como un moderno humanista multidisciplinares, sepan que, entre otras, ha publicado un libro sobre materia tan exótica al derecho como la construcción naval del régimen de autopromoción. Tampoco entraré en el análisis de sus publicaciones, siempre agudas y novedosas, innumerables, a las que no podemos hacer ni una simple cita. Me limitaría a pergeñar una escueta tarjeta de presentación de su figura. El profesor Peter Murray ha sido desde los años 90, durante más de 17 años, catedrático a tiempo completo de la Facultad de Derecho de la Universidad de Harvard. Las materias académicas en las que ha centrado su investigación y su docencia han sido el derecho privado y, más concretamente, el procedimiento civil y derecho procesal comparado, las instituciones legales y judiciales comparadas y las profesiones jurídicas. Hace 8 años, en 2010, se jubiló, pero siguió impartiendo clases en la misma prestigiosa Universidad de Harvard sobre las mismas materias a tiempo parcial. Lógicamente, su actividad académica, sus libros, artículos y conferencias en todo el mundo, Europa, América y Asia, etc., son también de imposible enumeración. Tampoco podemos detallar ni los cargos que ha desempeñado ni los premios y honores que ha recibido este eximio y brillante profesor. Sí hay que destacar que, como ya se indicó, en 1998, alternando con su cátedra en Harvard, fue profesor visitor Fulbright de la Universidad de Friburgo. Allí explicó el sistema legal estadounidense durante varios años, pero también estudió y analizó el sistema jurídico alemán, llegando a hacer meritorias y muy interesantes publicaciones sobre este derecho. Destaca un irrelevante libro sobre el derecho civil alemán y otro específico sobre su derecho notarial. Con todo el merecimiento de él, fue el redactor para la Comisión Europea del informe que lleva su nombre, el famoso informe Murray, que resultó decisivo frente a las pretensiones discordantes de los solicitos anglosajones. Resulta así que el profesor Murray es un especialista y profundo conocedor de los dos sistemas de seguridad jurídica preventiva, el europeo continental a través de las instituciones legales alemanes y las estadounidenses, que paralelamente la sustituyen en su país. Él cree y sostiene que los juristas y legisladores estadounidenses pueden aprender mucho del estudio de los sistemas e instituciones jurídicas europeas. Profesor Murray, no le quito más tiempo. Muchas gracias por su presencia, que honra la cátedra de esta academia. Muchas gracias.
Mr. General Director of the Registries and Notaries, Mr. President of the Madrid Chamber of Notaries, Mr. Secretary of the Academy, Ms. Vice President of the Academy of Notaries, of the Chamber of Notaries, members of the Board of Directors of the Madrid Chamber of Notaries, and not last but not least, Mr. Bormann, President of the German Federal Chamber of Notaries, respected colleagues, ladies and gentlemen. Thank you, Mr. Secretary, for the generous introduction. My wife, Deborah, joins me in thanking the Academy for the invitation to speak tonight and bringing us here to do it. It's a pleasure and an honor for me to be able to speak with you here at this time. It was also a great pleasure for me to meet and work with Alvaro Lucchini Matteo and Maria Jesus Mazo Venera during their visit in the United States in the fall of 2018 for the World Bank Symposium on How Can Law Help Protect Individual Property Rights on November 5th in Washington, D.C. Alvaro and Maria Jesus are outstanding representatives of the Spanish preventive justice system and its academic community. They make Spain's voice heard in international councils on legal and economic study and reform. Now, as our world becomes smaller and international transactions become ever more commonplace, legal regimens and institutions that have existed for centuries undisturbed in their respective national cultures come under increasing scrutiny by persons, organizations, and institutions that do business or invest on an international scale. The increasing economic integration of the European Union in particular has generated many efforts to harmonize legal regimes and institutions in the interest of uniformity as well as supposed efficiency. International organizations such as the World Bank have also taken it upon themselves to evaluate local legal institutions relevant to real estate investment or business formation on a comparative basis. In recent years, the institution and function of civil law notaries has attracted increased attention and some critical comment or attempted regulation or deregulation by these international investors and governmental bodies. While all legal institutions merit sharp and critical scrutiny at all times, the role and function of European civil law notaries may not be fully understood by at least some of those who venture criticism of this ancient institution of preventive justice. Over the last 3 years, your speaker and Professor Rolf Stirner of the University of Freiburg, Germany, have been making a practical and comparative study of the function and role of German public notaries in real estate and corporate law transactions. Professor Stirner is a leading German procedural law academic who has studied the German notariate as an element of preventive law for several decades. Your speaker combines a law academic background in procedural and comparative law with practical experience with actual real estate transactions and corporate law matters as a U.S. practicing lawyer. My own work with civil law notaries dates back to a 2003 to 2007 project for the Conseil des Notariats de l'Union Européenne, that's a CNUE, on the comparison of real estate conveyancing costs among several civil law and common law EU jurisdictions, as well as the United States. Our study was commissioned by the German Federal Chamber of Notaries and has been supported and assisted by a number of individual German notaries who met with us and made it possible for us to observe actual transactions and client interactions in their respective offices. Our data collection included not only legal research and conversations with notaries, register officials, and others, but also 24 on-the-spot observations of notaries interacting with clients and authenticating a variety of real estate and corporate law transactions. The hope has been that by including an investigator from a common law background in the study team, the German notariate and its functions could be examined through fresh eyes, not already indoctrinated with reverence for this ancient legal institution. Our report was delivered to the German Federal Chamber of Notaries only a few weeks ago. The results of our study have been, for us at any rate, an increased awareness of not only the theoretical, but much more the practical value of the notarial function as a modern institution of preventive justice. It should be noted that the observations and conclusions of our study are based on the civil law notariate as it exists in Germany. Civil law notaries practice in many differing forms in the many nation-states with civil law legal traditions. Our conclusions should be applied with some caution to notarial systems in other jurisdictions. We have been informed, however, that the Spanish notariate maintains roles and standards very similar to those obtaining in Germany, so that the basic observations and conclusions of our study may apply pretty well to Spain. Preventive and restorative justice. It can be said that one of the important responsibilities of the modern nation-state is to provide its citizens with justice, a reasonable expectation that established and accepted norms will be adhered to and respected by all or nearly all of the citizenry. Once norms have been established, hopefully by democratic means, there are two paths to attempt to secure widespread compliance and respect for these norms. One of these paths is, quote, restorative justice, which seeks to secure compliance and safeguard expectations by providing a mechanism for the ascertainment of and redress of harm caused by failure to adhere to these norms. The other path is to establish institutions that in one way or another prevent lapses and resulting harms from happening in the first place. To drill down on this a little bit, there are many legal norms that exist and are to be respected, but have no intrinsic means of ensuring compliance. The restorative justice system, however, encourages compliance by providing parties injured by noncompliance with an ex post facto remedy against the transgressor. So, for example, systems for redress of different kinds of tort damages by suit, judgment, and execution are restorative justice systems. The norm requiring automobile drivers to drive with care is enforced by lawsuits by persons injured by careless driving who seek damages caused by the carelessness. The restorative justice system is comprehensive. It is a backstop to other forms of justice. It has the advantage of requiring only a modest public investment. It is self-starting and doesn't require government agencies to initiate proceedings. The costly machinery of justice is only invoked when an injured party has the motivation to do so. Preventive justice, on the other hand, is designed to avoid harm before it occurs by guiding the hands of the actors to follow the applicable norms. Systems for the prior inspection and licensing of drugs or food can be classified as preventive justice systems. Food inspection is supposed to prevent consumers from eating contaminated or dangerous foods. While persons harmed by eating such foods undoubtedly have ex post facto restorative justice remedies, the potential harm from poisoning justifies the increased expense of stepping in beforehand and taking some steps to prevent the harm from occurring. All modern legal systems consist of a mixture of institutions of preventive and restorative justice. Some tend to rely more on preventive justice than others. However, it would be a mistake to say that any legal system is purely preventative or restorative. And as the world economy becomes more complex and dangerous, preventive justice measures are increasingly being relied on to protect unwary citizens from a variety of physical, social, and economic threats. Although the Anglo-American legal world is sometimes characterized as favoring restorative justice, in fact, preventive justice measures are present on every side. Indeed, the 16th century statute of frauds that required that contracts for the transfer of real estate be in written form is an early measure of preventive justice. The idea was that requiring contracts for the sale of real estate be in writing would cut down on fraudulent oral dealings in what was the most important component of the economy at that time. Nowadays, preventive justice measures such as those requiring licensing of professionals and purveyors, inspection of food, drugs, and buildings, and mandatory representation by legal professionals in transactions such as guardianships and divorces, to name only a few, are to be found in almost every country. This having been said, the degree to which various legal regimens rely on institution of preventative justice does vary in some key areas. In particular, most countries with civil law traditions maintain the preventive law institution of the public notary for certain private law transactions, generally transfers of real estate, and sometimes aspects of the foundation and operation of artificial legal entities such as corporations. Although the origin of notaries can be traced to Roman law and the role of Roman courts in connection with certain then public transactions, My discussion tonight will not address the historical underpinnings of the Notariate, nor will my talk address the theoretical or jurisprudential concept of, quote, the public document, close quote, as, quote, authenticated by notaries and their procedures. Instead, my focus will be on the practical and policy-based value of the civil law notariate in modern economies at the outset of the 21st century. It will be submitted that many of the practical and policy considerations which may have led the Romans to confide certain kinds of important legal transactions to public, then quasi-public officials still have validity today. Nation-states with a common law legal tradition maintain their own institutions of preventive justice, but do not know the public notariate and the form it exists and functions in the civil law world. In particular, real estate transactions and most corporate law transactions are pretty much left to the parties themselves, with whatever expert assistance they may elect to employ, usually in the form of private lawyers, or, more recently, title and corporate service companies. This state of affairs is said to provide transaction participants with more freedom to structure their affairs without a legally mandated transaction officiant, but may have its own costs in terms of lack of neutral legal advice and a less than ideal level of legal certainty in some areas. The case for preventive justice in real estate and corporate law transactions. In contemporary society, as well as in bygone days, real estate ownership and transfer have a special legal status. In a very basic sense, sound systems for maintaining and transferring interests in real estate are fundamental to social and economic stability. Establishing, defining, and protecting claims to private ownership of the world's surface on which we all live requires legal mechanisms for transaction effectuation and record keeping of a high degree of integrity. At the same time, because real estate transactions have become ubiquitous within the populations of Western democracies for some centuries, some method to make sure that parties are properly advised about what may be the most significant legal act in their lives is equally important. The creation and governance of artificial legal entities, particularly when associated with limited liability of their owners and managers, also raises special challenges to a legal system. By allowing the creation and maintenance of corporations and limited liability companies, which enjoy limited liability and unlimited life, the state is delegating powers that would otherwise belong only to it. The very existence, as well as all of the powers and functions of such entities, depends on accurate and scrupulous legal drafting and record keeping, including some form of public registration. Corporate entities may also involve the participation of many natural persons of differing sophistication and bargaining power. Once again, easy and economical access to legal advice can be an important protection against one-sidedness or even fraud in corporate structures and functions. It would be possible to leave real estate and corporate legal transactions to the parties themselves, aided by whatever professional assistance they would choose to employ. Mistakes, inaccuracies, and even fraud would be left to the restorative justice system. Dissatisfied parties could sue ex post facto for either damages sustained or to achieve an equitable restructuring of the transaction. On the other hand, if a system could provide mechanisms that would prevent problems and dispute from arising by carefully and accurately documenting and then registering real estate and corporate law transactions, and by making sure that transaction participants had a reasonable understanding of the terms and conditions of the transaction they're entering into, bad results, misunderstandings, disputes, and the need for dispute resolution might be significantly lessened at a savings in cost and the social wear and tear of litigation. The old adage, an ounce of prevention is worth a pound of cure, is the mantra of preventative justice. Of course, when one is considering providing preventative justice for every transaction, In order to save potential disputes and costs that may only arise in a relatively handful, one must consider the costs that will be borne by everyone in order to protect the relatively few who might be harmed in the absence of the preventive justice measures. So reasonable cost and access by all transition participants are important considerations to keep in mind when deploying preventive justice measures in real estate and corporate law transactions. The role of the notary as an institution for preventive justice. The modern civil law notary is able to meet both preventive justice priorities in real estate and corporate contexts. Requirements for notarial authentication of real estate and corporate law transactions provides a guarantee that transactions are completed with a high level of skill and that the all-important registers are free of errors. By the same token, the required participation of a notary as a neutral lawyer for the situation in such transactions vouches safe to the parties good access to neutral legal advice that may prevent uninformed, improvident, or fraudulent transactions. Our actual observation of notarial effectuation of real estate transactions impressed us with the efficiency and quality of the performances of the notaries whom we saw in action. Information was quickly gathered from parties and easily accessed public registers. Necessary transfer documents were drafted. In-person contact between parties and notaries was meaningful. The notaries not only read the documents aloud, but also explained significant points and answered questions. Individual circumstances were accommodated. Contractual expectancies were protected pending completion through the use of preliminary registered notations. Completion was not unduly delayed. Notaries' performance in the corporate law context was similar. Parties provided information, potential issues were clarified, documents were drafted, everything was explained to the parties, and transaction to completion was not unduly delayed. Accurate and effective public registers serve to inform the parties and protect those relying on this information. The role of the notaries in explaining the transaction to the parties in person, reading the documents aloud, and being accessible for questions seemed to us to be of particular importance as a matter of preventive justice. Real estate and corporate law are recondite subjects to persons from the real world. If all parties are able to achieve a reasonable understanding of their legal actions and the consequences, it is less likely that they will leave the transaction with the kinds of differing views that lead to disputes later on. Another important feature of the German system is the quality and integrity of the land and commercial register systems, both of which depend on notarial input. Accurate and current land and corporate registration minimizes later disputes and enables parties to rely on the registered information. This saves time and costs otherwise associated with uncertainty, such as the various forms of insurance and the need to do ad hoc due diligence investigations. Finally, it appears to us that the notarial system can provide this significant degree of preventive law protection at a reasonable cost. Our study included analysis of the costs to the parties for several of the real estate and corporate law transactions observed. Among the various real estate transactions that we studied in depth and actually observed was the sale and purchase of a house in Hamburg, Germany. Complete notarial authentication of this real estate transaction of more or less average value, namely €380,000, cost the parties a total of €3,057, or approximately 0.8% of the purchase price. By the same token, we found that notarial authentication of corporate entities with lower and average capitalization was also not expensive. In Cologne, Germany, we studied and observed the formation of a limited liability company with two participants and €25,000 in initial capital. The cost for a notary to attend to the formation and file the necessary authentic documents in the commercial register cost the parties no more than €642.50, or about 2.5% of the original amount invested. Our study of the statutory fee schedule of the German notaries, which is based on transaction value, made it clear to us that there's a kind of cross-subsidy. German notarial fees are based on the monetary value of the transactions authenticated. Often the amount of work required to authenticate a higher value transaction is not much more than is required for a similar transaction with a smaller sum at stake. The transaction value-based fee schedule thus tends to provide a proportionately more generous level of compensation for higher value transactions, even taking into account increased liability exposure. The more generous compensation for higher value transaction makes it economically possible for notaries to perform lower value transactions at moderate fees. This arrangement is justified as a measure designed to foster access to full preventive justice for all parties, regardless of the amount at stake. Alternatives from the common law world. In England, the United States, and most of the other countries that share a common law tradition, real estate transfers and most corporate law transactions are left to the private marketplace, even to the extent of do-it-yourself. There is no institution of preventive justice that corresponds to the civil law notariate. In the United States, both real estate and corporate law are, quote, state law and therefore vary among the 50 states. Real estate records are merely recordations of the individual instruments of conveyance as they take place. Land registration, although introduced in several states around the turn of the 20th century, never became accepted or widely implemented, so that in all states, proof of land ownership is based on searches of recorded conveyances over several decades to generate confidence in the underlying title. Because of this uncertainty and the differing practices among or even within the particular states, the national secondary market for real estate mortgages now demands that mortgagees of real estate purchase title insurance policies to protect them from financial loss from defects in or failures of title. The cost of title insurance is significant, even though claims for defects in title are relatively rare. This is a good example of an expensive private solution to a weakness in the preventive law system. Every buyer and mortgagor must pay a premium in order to protect themselves or their lender from the consequences of the public failure to adopt and maintain a reliable title registration system. The actual work of effectuating real estate transactions is performed by lawyers, who generally represent one party, usually the bank, and now largely by title companies. These are corporate enterprises that offer real estate research and transaction closing services and also sell policies of title insurance. Although federal and state consumer protective laws now require multiple disclosure forms and other papers, there is no system to provide advice to transaction participants, who must rely on their own experience or advice they hire from private lawyers they retain themselves. When lawyers are retained by individual transaction participants, they may be subject to subtle conflicts of interest in advising other transaction parties who did not actually retain them. Title companies give no individual legal advice, but merely fill out the forms, make the filings, and disperse the proceeds. Corporate transactions are parallel. Corporate entities are organized by private lawyers as well as by corporation companies, and indeed by entrepreneurs themselves using do-it-yourself forms on the internet. Filing requirements are rudimentary and generally limited to the original certificate of organization and spare annual information reports. Persons seeking to determine the ownership, governance, and financial status of corporate entities cannot rely on any kind of public register, but have to perform due diligence inspection of internal corporate records and inquiry of corporate officials. In the corporate, as well as the real estate context, transaction participants generally lack any systematic neutral advice about the terms and consequences of the transactions they are entering into. They can and do hire private lawyers to advise them, but conflict of interest rules confine the lawyer's responsibility to the clients who retain them, leaving unrepresented corporate participants without advice on which they can rely. Corporation companies and the internet do not provide any individual legal advice, but leave the parties to what they can glean themselves from public available sources. This relatively unstructured system prevents parties to real estate and corporate law transactions a degree of freedom in structuring their arrangements at a potentially low initial cost, if they are willing to forego personalized legal advice and assistance and live with a degree of legal uncertainty or insure against it. The restorative justice system is left the task of remediating any errors or frauds that this somewhat more porous preventive justice system may not catch. In the case of real estate, financial losses from some of these may be covered by title insurance, which is purchased ex ante in anticipation of possible problems. There is no parallel system to insure against defects in corporate organization or governance. Although the relative absence of built-in preventive law structures would suggest that initial transaction costs in the U.S. would be lower than in Germany, our study suggested that this is not necessarily the case. Analysis of costs of actual transactions in both legal systems discloses that participant costs for notarial effectuation of real estate transactions of lower or average value tend to be similar or lower in Germany than the costs for title company or lawyer transaction closings, including title insurance, in typical American states. So, for instance, the cost in the state of Maine of effectuating the purchase and sale of a house with a value corresponding to the house in Hamburg would be about $3,775, or 0.83% of the amount of the transaction, just about the same as in Germany. The purchase and sale of such a property in a metropolitan area such as New York, however, where it is customary for both parties to be represented by lawyers, would generate costs in the vicinity of $7,000, substantially more than in Germany. Only in transactions at the upper end of the value scale does the American system have any discernible cost advantage. By the same token, U.S. corporate law transactions vary significantly based upon the degree of advice obtained by the participants from party lawyers, ranging from do-it-yourself formations without any advice to larger and more complex transactions involving several lawyers, representing various participant interests. However, putting aside the extreme case of totally unrepresented parties organizing entities on the internet or with the help of a corporation company, the costs of formation of a small LLC or stock corporation with legal assistance from at least one attorney would be of the same order as the costs of having it done by a notary in Germany. In most of the American states, we estimated that the cost of organizing a limited liability company similar to the one we observed in Cologne would be approximately $600 to $1,500, depending upon the extent to which the parties obtained actual advice from lawyers. These costs range from a level that is practically the same as in Germany at the low end to amounts considerably in excess of German notarial fees in situations where more than one lawyer is involved. Costs for more complex transactions depend on the number and sophistication of the parties and the kind of transaction involved and are very hard to compare. However, we did observe that the amount of due diligence needed to determine capitalization, governance, and financial status of corporate entities is significantly greater in the United States than in Germany, where much of this information is reliably provided by public registers. Comparative advantages and drawbacks. Economic globalization, and in particular the internationalization of financial investment and the global flow of money, has focused attention on the differences among national legal regimens as they may affect the ease, reliability, or cost of cross-border investing. Comparative law, once the province of law academics, has become of interest to international entrepreneurs, speculators, and financiers. It's not surprising that we find that national legal systems, reflecting the history and cultural priority of long-established nation-states, are being compared and evaluated for their, quote, business friendliness, close quote, based on the priority of these financial actors. Looked at from the standpoint of traditional comparative law criteria, the function of notaries in real estate and corporate law transaction compares favorably with how such transactions are handled in the common law world. Two advantages stand out. One, the required availability of sound, neutral advice for all transaction participants, regardless of financial ability or amount at stake. And two, maintenance of strong and accurate public register systems on which good faith parties can rely for information on real estate title and encumbrances and corporate governance and capitalization. For low and medium-sized transactions, these positive features are provided at a cost that is comparable to the low-cost common law alternative. Notarial authentication of higher value transactions may cost a little more than would be the case in England or the US. That extra margin helps subsidize notarial competence for lower value transactions that alone might not be compensable. It may be that innovations such as real estate conveyancing by real estate brokers and do-it-yourself corporate formation may be introduced more readily in the more permissive legal cultures. However, these developments entail their own costs in terms of lack of expert advice for all participants, or scrupulous transaction completion and accurate registers. The restorative justice system, already creaky in many jurisdictions, may not be able to compensate for uncertainty costs and actual harms suffered by participants in these new forms of transactions. Recent developments in the European Union suggest it may be possible to offer corporate formation on the Internet under the oversight of notaries, thus combining cost savings with maintenance of standards of quality. In recent years, economic studies by and for the Organization for Economic Cooperation and Development and the World Bank have attempted to rank various legal regimens based on various criteria associated with ease of business startup or receptiveness to international investment or development. Our review of several of these studies that purported to compare notarial systems to others concluded that the rating criteria, largely focusing on prompt, effective, and economical effectuation of real estate and corporate transactions, did not give enough weight to the value of informed transaction participants or the enhanced legal certainty provided by modern notarial systems such as those in Germany and Spain. In some cases, adverse comments have been based on artificial dividing of the authentication function into many steps, ignoring the reality that the overall time required for notaries to complete the transaction was far from excessive. In other studies, time and cost estimates for notarial performances in jurisdictions such as Spain and Germany were averaged with time and costs in unreformed and archaic notarial systems of third world countries. Ultimately, in many of these studies, major European notarial systems were rated comparatively well even against free enterprise common law systems in terms of both transaction cost and celerity. Held to a reasonable objective standard, most of the OECD and World Bank studies furnish no grounds for questioning the values or performance of European notarial systems. By the same token, it is to be hoped that the recent enthusiasm within the EU leadership for deregulation and competition among professional service providers is also abating in light of the realization that many professions, with the notariate in the lead, cultivate and preserve public policies and values that would be underserved by a purely competitive service provider regime. The recent tussles between the EU Commission and the notarial profession may have had the effect of forcing all parties to focus more on the fundamental values of notarial authentication and the role of notaries and instruments as instruments of important public policies. The recent EU directive allowing a continuing role for preventive justice in connection with the online formation of corporate entities is an encouraging sign that Europe's own governing councils are beginning to understand the continuing value of preventive justice. A look to the future. Looking from the outside, so to speak, it would be your speaker's view that the future looks very promising for notaries in modern European jurisdictions such as Spain and Germany. Notaries have not lagged in the adoption of new technology that enables them to perform their historic preventive law function with greater efficiencies. In many jurisdictions, modern notaries have been in the forefront of digitalization of documentation, registers, and transmissions, resulting in quicker transaction completion and easier access to register information. In Germany, and in particular Spain, large areas of non-contentious voluntary judicial activity is being transferred from public judges to notaries, even to the point of authorizing notaries to make fact determination and quasi-judicial rulings. As neutral authenticators of important private law transactions, notaries are well suited to function in a mediative role in other legal matters that parties can likely resolve by agreement. In Germany, we see notaries providing over negotiated settlements of litigation. In Spain, recent legislation authorizes parties to obtain divorces by agreements authenticated by Spanish notaries. This is a logical step that builds on the notary's established independence and public responsibility. There's every reason to expect that this step will provide the public with more prompt and accessible service without a dilution in standards. The notary's strongest protection in the current political and economic climate is your role as expert neutral authenticators of significant legal transactions, whether they be real estate transfers or creation and maintenance of artificial business entities. In these contexts, the case for neutral advice to all transition participants and expert implementation, including the maintenance of accurate and reliable public registers, is very convincing. In this role, the notaries do indeed perform an important public function. This does not mean that notaries should not be ever mindful of reforms in their practices in order to take advantage of modern technology, but that do not impinge on their essential roles. For instance, the ancient practice of reading the entirety of an authentic document aloud in the presence of the parties likely has continued validity for real estate and even small corporate transactions that frequently involve unsophisticated participants. The reading aloud guarantees that the parties have been exposed to the content of the document and gives opportunities for explanations and questions. However, in more sophisticated corporate and real estate transactions, in which most participants are represented by their own lawyers, it seems questionable whether reading long and prolix legal documents aloud, sometimes for hours, is anything but a relic of earlier and simpler times. The jurisprudential notion of reading aloud as essential to authentication may well yield to the practical context in which it would be performed. Notaries should be careful to protect themselves from the, quote, law as a business, close quote, concept that over the last 30 years has tended to reduce attorneys at law to simple money-grubbing service providers in many legal cultures. Notaries are private professionals with public responsibilities. However, the notarial function is not a business. There is a borderline between adoption of technologically efficient practices within a notarial office and reorienting the practice toward maximizing income and profit, even at a cost. Organization of notarial practices into larger entities that might generate more business or higher profits, relationships with lawyers or repeat business clients that cast doubt on notaries' independence, and arrangements that permit retiring notaries to profit from the transaction of their practices to successors will undermine the core of notarial legitimacy and ultimately the notariate itself. Notaries and their function are closely regulated and protected in many civil law legal regimens. Regulations that limit the number of notaries, require that certain legal acts can only be performed by notaries, maintain uniform statutory fees, usually based on transaction value, have met mounting skepticism within the EU with its policies in favor of free movement of professional service providers. Some EU member states have taken steps to deregulate their notariates in hopes that the marketplace competition will result in easier access or lower costs for notarial services. Although it is too soon to judge the long-term effect of these measures, already there are grounds to suspect that this kind of deregulation may result in disadvantage to parties to lower value transactions and a possible diminution of the quality of notarial services available to them. Deregulation should be addressed with some real caution. It is not a panacea. It is important that notaries are able to correlate regulations that are important to the integrity and success of the profession with the public policies affected by the notarial function. Regulations perceived by the public to be primarily intended to protect notaries' incomes may be improvidently cast aside without consideration of the ultimate value of the regulation for notaries' vital independence or neutrality. There's a risk that, as we would say, the baby will be thrown out with the bathwater. Which brings me to my last point. With globalization of the economy and free international flow of investment capital, the need for reciprocal understanding of diverse legal regimens and cultures is of greatly increased importance. There was a time not too many years ago when an American lawyer needed only to know American law. There was too little direct contact with foreign legal systems to make it worth the time to become informed. Those times are long gone. Every participant in the modern economy and investment world needs to have at least some understanding of many legal regimens in order to be able to effectively participate in the global economy and make international investments. It is surprising how many international actors and regulators are relatively ignorant about important features of the legal regimens of major world economies. Our recent visit at the World Bank Symposium in November 2018 surprised your speaker with how many World Bank functionaries seem to have little or no understanding of the function of civil law notaries in countries such as Spain and Germany. It appears that a large portion of the distrust and skepticism toward notaries that one reads in World Bank and OECD studies may be based on lack of real familiarity with the role and workings of notarial systems in modern economies. Under these circumstances, notaries need to redouble their efforts to educate the common law and developing world on the value of preventive justice and the role of notaries as neutral transaction professionals with public responsibilities in providing preventive justice in an efficient and reputable manner. It is important that the advantage of preventive justice are not relegated to a back seat in international discussions of international business and investment opportunities. Our investigation has shown that preventive justice in most real estate and corporate law transactions costs no more and takes no more time than leaving those transactions more or less to the competitive service market. And in Germany at any event, notaries are able to provide greater legal certainty and participant autonomy than one is able to achieve with private lawyers and title and corporation companies in the United States. This message deserves to be delivered at World Economic Forum and in the literature of international transactions and investment. Notaries should not, again, I'm going to use an American expression, should not hide their candle under a bushel, but should be encouraged to assert the advantage of the preventive law systems on the world stage. As various legal cultures look to reforming their legal systems to improve quality and address abuses, the modern notarial system, as it exists in Germany and Spain, should be an accessible example of the sound applications of principles of preventive justice in modern cultures and economies. Thank you. Thank you.
Muchas gracias, profesor Murray, por sus enseñanzas, por extender ese mensaje que los notarios tenemos también que irradiar hacia afuera en este mundo global. Y muchísimas gracias de verdad por esta magnífica conferencia. A continuación se va a servir un vino español en homenaje del matrimonio, que está aquí también su esposa, del matrimonio Murray.